Maintenance Report for County of Washington, State of Michigan.
You may be seated. We're back on the record in the case of People versus Shonda Jefferson. In this matter, the court has heard this case, and really the issue becomes the issue of posing or causing an unreasonable risk of harm or physical injury to a child. It isn't really the issue of whether or not the child was injured or anything along those lines. Was something done that posed an unreasonable risk of harm to the child? As I was thinking back through the video, a number of things occurred. And as the court was considering its decision, one thing that I realized is, I think in dealing with children is I'm listening to the protocols. The reality is you can have all protocols in place that you want. But once something starts to occur, some of those don't quite come into play. And so there may be some leeway in terms of that. So in terms of what the child was doing initially, I personally and may have issues with what was transpiring at that point. But then, and this is really the legal analysis, the defendant's behavior and what the defendant did begins to cross the line. And there are really 3 points at which it crosses the line. The first point at which it crosses the line is placing the child in that seat at all without some justification as to why that should be done. This child could have been absolutely out of control. There's something else to do. You can't just decide, I'm going to basically strap a child down when the policy doesn't call for it. So that's the one thing. But then the manner in which the defendant went about implementing that violation of policy also causes a problem. There are 2 swings that I don't, in looking at the video, don't believe were defensive maneuvers on the defendant's part to block or stop something. One occurs as the child goes into the seat. There is a swing toward the child. There is then also one coming over the back. I can't say because there were angle that contact wasn't being, or that contact was made, or that any harm, but to even raise your hand in that fashion and swing in that fashion is inappropriate. But really by virtue, so those are really the 3 points. By virtue of placing the child in the seat, the manner in which the child was placed in the seat, this court does believe that the people have sustained their burden of showing that the defendant did indeed violate the statute and did cause an unreasonable risk of harm to this minor child. And so for those reasons, the court would find that the defendant is guilty of child abuse in the 4th degree. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be August 9th, 2023, 9 a.m. That will be via Zoom. And ma'am, what I would suggest that you do is probation is right down the hallway. Stop there before you leave the building so that they can get you everything. Okay? Thank you, folks. Bond will continue.
Thank you.
14A stands adjourned. Court does call the case, People versus Anthony Williams.
Good morning, Assistant Public Defender Lauren Parent on behalf of Mr. Williams, who is approaching the podium. Mr. Williams, will you give us a state your name for the record?
Anthony Williams. Where is that?
And Your Honor, today's the date and time set for a bond violation hearing. At the probable cause conference last Thursday, we did address these violations on the record where the defendant was blowing numbers. It's my understanding that he didn't deny blowing the numbers, but I don't recall what he stated the reason was.
Your Honor, my client says that he was consuming NyQuil and that's why he blew the positive numbers. He does deny that he drank any alcohol, and says that the numbers came from NyQuil.
Well, okay, so he says he's drinking NyQuil.
Yes.
And that NyQuil brought him up to these numbers of 0.053.
Yes, I think the highest one was a 0.09, and he does say that he consumed quite a bit of NyQuil.
Really? Your client does realize that NyQuil contains some alcohol.
Yes, yes.
So he's not disputing that the numbers are on here. He's just saying the reason he did that, because your client's also aware, though, that he is not to consume any alcohol from whatever source.
He says he, and correct me if I'm wrong, Mr. Williams, he says he was not informed of that when he got the sober link or sober link device from community.
Look, counsel, I don't mind having a hearing on it. I don't know what you're going to put forth. He's admitted that he's doing that he drank something containing alcohol. We can get the paperwork where it will indicate that he's not to consume alcohol from whatever source.
Right.
But, you know, so that you can be prepared for this, appreciate my skepticism, because the amount of NyQuil that you would have to drink to get to an 09
is significant, Your Honor, and I have.
significant in like a number of bottles.
Yeah, I have had these conversations with him, and he
Does he understand that that I will also, honesty I can deal with where people make a mistake. If people make a mistake and then initially lie about it, okay, sometimes that happens. But that if he's coming to me with that story today, we're going to have a problem.
Yes, we have had these conversations. I think that's fair, Mr. Williams. I've explained the judge's probable stance on.
I told him I messed up. I'm gonna do it again.
Do you want me to get the paperwork that says that he's not to consume alcohol from any source? Because that seems to me to be the only issue.
My understanding from community corrections is that paperwork is given to every single person that is a consumer of community corrections, and that they sign that paperwork. So that would be quite easy to get over to the court and to Ms. Brennan.
Judge, I mean, he maintains he only consumed NyQuil and he didn't receive the paperwork.
Let me just say, if I assume that to be correct, he's admitted drinking NyQuil. Assume that's correct. Don't believe it's correct, but what the heck? Just take him at his word. Then the only issue becomes whether or not he would have received notification that consuming alcohol from any source would be a violation.
Correct.
Would you agree?
Correct, yes.
All right. Then, Ms. Kirby, how long will that take us to get that paperwork on him?
I'm messaging community corrections right now, and I should be able to get it within the next 15 minutes.
Okay. So while we await that paperwork, and you're going to have to be able to go over that paperwork with your client, I'm going to remand the defendant to custody. And then once that paperwork comes in, we'll get it to you, counsel, and then we can go from there. Defendant's remanded at this time, pending the continuation of the hearing.
Thank you, Your Honor.
Mr. Ellman, you want to go next? No, I'm kidding. I'm kidding. Just
I'm trying to think of a good joke to tell.
Court does recall the case of the People versus Anthony Williams.
On behalf of the people.
Well, we seem to be missing somebody, like a public defender.
Apologies, Your Honor. Assistant Public Defender Lauren Perry on behalf of Mr. Williams.
All right. Okay, we have received the documentation from the from Community Corrections regarding the sober link, and you've had an opportunity to see that, review it, and go over it with your client.
That's correct, Your Honor. I did have another conversation with him both about that paperwork and the tests. He would now like to admit to consuming alcohol while on the sober link device, to go back to the original allegation and the violation. I think he's struggling.
He now admits to the violation?
Yes, that's correct. I think he's struggling kind of coming to terms with his alcohol problem.
Truth? No, I'm sorry. I don't mean to interrupt you. Go ahead, Ken.
Right, Your Honor. I mean, his alcohol problem, we did discuss, the possibility of treatment, and he is open to treatment. We did discuss an alcohol assessment. I think we want to start there. And he was open to that as well. I talked to him about getting our social workers involved to see what we can do for him to get that process starting. But I really do think that, it took him a while to admit to having a problem, but he does say he messed up, and he acknowledges that, and now wants to fully admit to all the allegations.
Is that correct, young man? You admit to the violations?
Yes, sir.
Anything you want to say before I sentence you on these violations?
No, sir. No, sir.
Why were you lying about it? That was a question.
Yes, I just got alcohol. Probably needed some help.
Do we have a new hearing date set on this? During the pretrial in this matter, which was also set for today, October 4th, 2023, 9 a.m. Regarding your sentence on this matter, young man, and I said it before you went and back, that, I can deal with people who are going to tell me the truth, and then we can go from there. But when you're going to do that, and then you lie about it, and everybody's got to go through all of these machinations to try to figure that out. And I told you what this form was going to say about consuming alcohol. So even if you were able to down that much NyQuil, which I don't know that physically you would, I think that you would pass out before you would get to an 09, but that's okay. You still persisted, and to what end? I mean, the reality is that if you had asked somebody for help, certainly if you had asked your attorney for help, they would have found a way with what she's laid out here today. But you wanted to take the hard road. Maybe from that you'll learn that that's not necessarily the way to go about doing things. Sense of the court on the violation: 30 days, Washtenaw County Jail. Court will consider release if there is inpatient treatment. Defendant remanded.
Throughout the case, we saw the delicate balance judges must strike, punishing violations while encouraging rehabilitation. The defendant's repeated excuses only made the situation worse, reinforcing that honesty with the court is crucial if you want leniency.